Good afternoon, Chair Bozen, members of the Judiciary Committee. I am Hannah Murdoch, H-A-N-N-A-M-U-R-D-O-C-H. I'm Senator Megan Hunt's legislative aide, and I'm here today to present LB386 on her behalf. Senator Hunt wanted to relay to the testifiers that took the time to be here today because they care about this bill or our next bill up on the agenda that she is grateful for your time and advocacy, and that her absence is not a reflection of lack of commitment to these bills. This is a rare occasion in which she's opted to remain in the government committee on which she serves so that she can participate in the hearing for a very high-stakes bill that's being heard there this afternoon. So just know that under other circumstances, she'd be here presenting and listening to your testimony today, because these are some very great bills worthy of consideration by this legislature. And now I will read her opening statement for LB386 into the record, and I'll note that I'm going to read her statement in her voice, so when I say I from here on out, I'm speaking on behalf of Senator Hunt and not myself. LB386 would create a Bill of Rights for Nebraska youth in the foster care system. This is a bill that I brought a few times before, in 2020, 2021, and 2023. In response to an interim study resolution I brought in 2019. The most recent effort in 2023 didn't get a chance to see an executive session, and I didn't get a priority for it, so it just didn't move, but I think it had the votes. In 2021, I had LB387, which got to general file but sat on the worksheet because it didn't have a priority and we just didn't get to it. Now, in my final biennium, I wanted to take a final swing at this because this is a bill which is non-controversial, which has been really fine-tuned through extensive stakeholder input, and which stands to really make a difference for some of our most vulnerable kids at no cost to us. I brought this again this year at the urging of the Nebraska Children and Families Foundation, who tells me that they continue to hear from current and former foster youth about a real need and desire to see this passed. So I believe you'll hear from some of them after me. As background, in 2019, I introduced LR127 at the request of youth advocates and former foster youth to explore opportunities to clarify rights for Nebraska youth in state custody. After 3 listening sessions with over 50 current and former foster youth in Fremont, Lincoln, and Omaha, it became clear that youth involved in the welfare system did not know about the rights they had while in foster care. That study informed my LB941 in 2020, which was drafted based on input from youth advocates. This year's bill is the product of further input and collaboration among stakeholders to improve upon the work we did on previous iterations of the bill to remove opposition, and incorporates the committee amendment from the last time it was advanced. That amendment was a hard-fought compromise we worked diligently on with DHHS, the Nebraska Court Improvement Project, county attorneys, and foster youth advocates in order to bring all agency opposition to neutral. Over 20 advocates with experience in Nebraska's foster care systems shared their input in the creation of this Youth and Care Bill of Rights, so it's been thoroughly vetted. LB386 also incorporates an amendment requested last time by Douglas County Sheriff Aaron Hansen. Previously, we had included YRTC youth in the bill. However, through discussions with the sheriff, we came to understand that many of the rights in the bill couldn't be implemented in the same way for YRTC youth. For example, guaranteeing youths in these facilities the rights to access religious services, equal opportunity for recreation, and family interaction cannot reasonably be guaranteed or put into practice in the same way as for children in foster care placements. We felt this was a reasonable concern and, as such, removed them from the bill. I'm grateful for the sheriff's input, and I'm happy to work to get the bill to a place where it can earn his support. LB368 would create a detailed list of rights as it pertains to youth and child welfare placements. That includes youth in foster family homes and in child caring institutions. The rights enumerated in the bill include things like their right to remain connected to family members, to live in an environment that accepts their culture and allows them to practice their own religious beliefs, to receive support for their basic needs, to file a grievance if they feel their rights are being violated, and to be informed about and participate in any court proceedings related to their case. The bill specifies that youth age 14 and up will be provided this information about their rights in a developmentally appropriate manner by their caseworker at initial placement and at regular intervals thereafter. I've had some questions about some specific pieces of the bill, like, will this allow the youth to decline to participate in, say, a court-ordered drug or mental health treatment program? And the answer to that is no. We enumerate a list of rights in the bill with the caveat that the youth may exercise these rights if it would not be in violation of any court order or deemed contrary to the best interest of the child's health, safety, and well-being. So it is not a free-for-all to give these youth unfettered decision-making power. The court, the department, and their guardians still maintain ultimate authority here. It's just meant to give them a better understanding of the basic things they should be entitled to and have the freedom to do if it is reasonably within the bounds of what the court has determined is in their best interest. Currently, DHHS is federally required to provide youth with notice of certain rights by the Federal Strengthening Families Act, and this is codified in state statute. However, foster youth have indicated to me and their advocates that the notice given and the rights listed therein are inadequate. None of the youth in our listening sessions indicated that they remembered having received notice of their rights when they entered the system. Current statute states that youth are informed of their rights by DHHS during their first 72 hours in care. Youth we spoke to indicated that if they are only informed of their rights during that initial removal period from their family home, the trauma of that moment prevents them from retaining and processing the information. Young people want these conversations to occur both initially and consistently afterward, so that they are periodically reminded of their rights as they move through the foster system. 15 states have enacted similar bills of rights for youth in their welfare systems, which is a pretty good indicator that the federal requirement doesn't go far enough. As an overview, the bill does 3 key things. 1, it ensures that youth in care are given notice of their rights. 2, it requires that youth are informed when they first enter the foster system and at regular intervals after that by their caseworker. And 3, that they are made aware of how to file a complaint through a grievance process if they believe their rights have been violated. I have an amendment, if we can distribute that, AM 210, that was requested by the Sarpy County Attorney's Office this morning. It's just a small technical cleanup change to clarify our intent in terms of the population that the bill refers to. So we were happy to accommodate and appreciate them pointing this out. In Section 1, Sub A, where we lay out which youths the Bill of Rights would apply to, they let us know that there are actually some juvenile delinquency cases in which probation actually places kids in foster homes for a short-term respite to allow parents and kids to calm down and take a breather while more permanent therapeutic arrangements are being made. So as written, the introduced copy would technically include that small group as well, which wasn't our intention because they are not under DHHS jurisdiction. So AM 210 simply adds the proper language to clarify that we're narrowly addressing the child welfare population when it comes to foster placements. I'll let you read through the specifics of the rights enumerated in the bill and wrap it up here to let our testifiers speak more about the details. In summary, LB386 incorporates feedback from the Nebraska Children's Commission, Nebraska Appleseed's Child Welfare Attorneys, DHHS, the Nebraska Court Improvement Project, the county attorneys, and current and former foster system involved youth. You'll see that supportive testimony was submitted for the record by the State Foster Care Review Board, the Nebraska Association for Behavioral Health Organizations, the Nebraska Psychological Association, the Nebraska Alliance of Child Advocacy Centers, the Nebraska chapter of the National Association of Social Workers, and lived experience advocates. The purpose of this bill is to make sure that youth are aware of what their rights are, and how they can advocate for themselves while navigating an unfamiliar system in an often difficult time of their lives. For a vulnerable young person, there is an inherent distrust of a system that removes them from their home and puts them in an unfamiliar place. It is the state's responsibility to do everything we can to ease these types of transitions for children in our care. The least we can do is make sure that these young people know that they do have rights and encourage them that they can speak up and have recourse if something feels wrong. Please advance LB386 with AM 210. Thank you.
Typically, we don't ask questions of introducers when it's not the senator themselves, so we'll just begin with our first proponent unless you're wanting to elaborate. Are you going to do close? Or are you...
I will stick around because
Okay.
I'm going to do the next one too.
Oh, that's right.